The exact moment the Supreme Court dropped its unanimous 9-0 emergency ruling, it didn't just ripple through the system, it detonated. No heads up, no leaks, no soft rollout. Just a sudden legal shockwave that sent governors, agencies, and entire state legislatures into instant crisis mode. Phones exploded with calls. Legal teams were dragged out of bed. Emergency briefings were scheduled before coffee. Even Capitol Hill insiders admitted they were blindsided. And honestly, they should have been. This wasn't some quiet procedural tweak or a minor clarification buried in legalese. This was the highest court in the land, every single justice, left to right, speaking in one voice, dropping a constitutional bombshell that's about to redraw the boundaries of American law. A 9-0 decision is rare. A 9-0 emergency decision with nationwide fallout? That's practically mythic. And the message was loud and clear. The legal ground beneath our feet is shifting, fast. This wasn't a gentle nudge. It was a full-on constitutional collision. For months, court watchers braced for tension. Maybe a split decision, maybe another 5-4 nail-biter. But no one predicted unanimity. Not from this court, not on this issue. Yet, here we are. Every justice, liberal, conservative, originalist, pragmatist, agreed. The lower courts blew it. They overreached, misread precedent, or just ignored the Constitution altogether. And when the Supreme Court locks arms like that, there's no higher appeal, no workaround, no spin. Overnight, restrictive states went into panic mode. Constitutional scholars popped champagne. Lawmakers stared at their own statutes like they were suddenly radioactive. The case itself, it was supposed to vanish into the lower court abyss, delayed, diluted, or dodged. Instead, the court snatched it, fast, aggressively. That's not something they do unless they believe the Constitution itself is on the line. The core question, can states keep building regulatory walls that clash with rights already locked in by landmark rulings like Bruin, McDonald, and Heller? The court's answer, at least for now, is a deafening no. But this order isn't just about one case. It's a blanket freeze on lower court rulings that upheld tight restrictions. It's a demand for immediate re-review under stricter constitutional lenses. And it's a warning shot. Any state still trying to dodge Supreme Court precedent is now on borrowed time. This isn't just a legal tweak, it's a constitutional reset. A reminder, the court sets the boundaries, not governors, not agencies, not activist legislatures, and here's where it gets nuclear. Buried in this order is a roadmap for legal demolition. Analysts say 7 major legal categories are now in the crosshairs. 1. Permission-based licensing systems, where you need a bureaucrat's blessing to exercise a right, are now under the microscope. If they delay, judge, or gatekeep arbitrarily, they're probably toast. 2. Sensitive place overloads. The post-Bruin trend of turning every park, bus stop, and library into a no-go zone could be wiped out nationwide. 3. Bans on common items, especially those owned by millions of law-abiding citizens, are now legally shaky. 4. Waiting periods, especially those rooted in emotional assumptions rather than historical precedent, may not survive. 5. Registration schemes that force people to hand over private data just to exercise a right. Those are now on the chopping block. 6. Subjective denial systems, where officials can reject rights based on gut feelings, are facing extinction. 7. Any law built on public safety balancing instead of historical tradition is now constitutionally suspect. But let's be clear, this isn't just about guns. This is about how courts treat rights, period. For years, states have tried to lawyer their way around Supreme Court precedent with creative loopholes, slow-walked compliance, or stacked red tape. This order, it's the court slamming the door on that game. The message, rights aren't negotiable. You don't get to redesign them with legislative duct tape, and if you try, the court will drop a 9-0 hammer on you, no matter your politics. Legal scholars are already calling this the most important unanimous constitutional move in a generation. Why? Because 9-0 isn't political, it's structural. It says this isn't a gray area. It's not up for debate. It's so foundational that even justices who disagree on everything else found common ground. And if this is the preview, the main ruling expected next year could be earth-shattering, a full-scale realignment of how rights are enforced across the country. State attorneys general know it. They're already in emergency mode. Legal memos are being rewritten. Laws are being flagged as constitutionally doomed doomed. Advocacy groups are gearing up for a brawl that could dominate the next decade. But here's the real kicker. The court didn't just slap down one law, it called out the chaos of inconsistent standards across states. The Constitution, it implied, can't mean one thing in Texas and the opposite in California. That's a direct signal that the court may be prepping to impose a single national standard, a unified rule that applies in every state, every city, every county. That would be historic. It would vaporize the legal patchwork that's let states play constitutional hide-and-seek for decades. And it would finally mean equal rights no matter your zip code. The fallout is already political nitroglycerin. Gun control groups are screaming that this guts state autonomy and puts lives at risk. They warn of regulatory collapse. On the flip side, rights advocates are calling it justice delayed but not denied, a long overdue correction to years of unconstitutional bullying. They say the 9-0 vote proves just how far some states wandered from the Constitution, and they see this as the turning point, the moment the tide finally rolled back in favor of individual liberty. Congress is reeling. Some lawmakers are scrambling to draft emergency bills to protect state power, though most know that's a losing battle. Others are pushing to federalize standards in line with the court's direction. Even the DOJ is quietly prepping for national-level restructuring, knowing that if the final ruling drops the way experts expect, entire legal frameworks could evaporate overnight. This isn't just a case anymore. It's a constitutional showdown, and what comes next could redefine the balance of power between states and the federal government for decades. If the court pulls the trigger and strikes down permitting systems, discretionary bans, or registration schemes, whole agencies could lose authority instantly. There's a growing sense that we're on the edge of a legal transformation that can't be stopped. Governors feel it. AGs feel it. Lawmakers feel it. And millions of Americans watching this unfold, they can feel the shift. This isn't the final ruling, but it is the warning, a unanimous warning, a declaration that the court is done tolerating constitutional erosion, that rights aren't optional, that the Constitution doesn't bend to political pressure, media spin, or state-level gamesmanship, that if states won't respect it, the court will tear their systems down, brick by brick. The next few months will be legal warfare, more filings, more frozen rulings, more states scrambling to rewrite laws they now know are living on borrowed time, and when the final decision lands, the aftershock could reshape America in ways we haven't seen since the incorporation era. Because this 9-0 emergency order wasn't just a legal footnote, it was a constitutional flare gun, a national alarm bell, a landmark moment that will be studied, debated, and remembered for generations. The laws of this country are about to change, and the Supreme Court just made sure no one can say they didn't see it coming.